In the previous section, we examined the legal foundation of employment agreements between brokers and their licensees. Now, we shift focus to another vital layer of real estate employment contracts: the listing and buyer employment agreements. These documents serve as the legal bridge between the brokerage and the public, establishing agency, compensation, and authority. While the employment agreement defines the relationship within the brokerage, the listing and buyer agreements define the professional relationship between the broker and the client. Both agreements must comply with ARS, paragraph 32-2151.02, and Commissioner's Rule R428-1101, which require all real estate employment agreements to be written, signed by all parties, and contain essential elements that make them valid and enforceable. These agreements are considered employment contracts because they authorize the broker to act on behalf of the client in the purchase, sale, or lease of real property for compensation. Required elements in listing and buyer employment agreements. Under Arizona law, several elements must be present in both listing and buyer employment agreements to ensure validity and enforceability. These include definite duration of the agreement. All real estate employment agreements contain a definite expiration date. Open-ended or perpetual agreements are prohibited. For example, a listing agreement that states, "This contract continues until the property sells," would be invalid under Arizona law because it lacks a specific end date. Identification of the parties and property. The agreement must clearly identify the parties involved, the broker and the client, as well as the property in question. In a listing agreement, this would include the legal description or street address of the property being sold. In a buyer employment agreement, it would identify the buyer and the types of properties they are seeking. The buyer employment agreement would also spell out the amount OC commission the buyer agrees to pay the agent with a successful close on a property. Signature of all parties. Both the client and the designated broker or authorized agent must sign the agreement. This satisfies the statute of frauds under ARS, paragraph 44-10017, which requires contracts for real estate services to be in writing and signed by the party to be charged. Compensation and payment terms. The agreement must specify how and when the broker will be compensated. This includes the commission rate or fee structure and whether it will be paid by the seller, buyer, or both. For example, a buyer-broker agreement may state that the broker's fee is a certain % of the purchase price, payable from the seller's proceeds at closing. Broker's duties and authorization. The agreement must grant the broker authority to act on behalf of the client, outlining the broker's fiduciary responsibilities such as loyalty, confidentiality, disclosure, obedience, and reasonable care. These duties are consistent with R428-1101A, which defines the broker's obligations to clients. Elements not required but commonly included. While not legally required, many listing and buyer employment agreements include additional terms for clarity, protection, or convenience. These may include cancellation clauses, allowing either party to terminate early under certain conditions, dispute resolution, arbitration or mediation procedures to resolve conflicts, marketing plans, descriptions of how the property will be marketed or how the broker will locate properties for the buyer, dual agency consent, required if the broker may represent both buyer and seller in the same transaction, as outlined in R428-1101F. These optional provisions are valuable because they help set clear expectations, prevent misunderstandings, and promote smooth transactions. However, including them does not replace or override the mandatory elements required by law. Elements prohibited or not required. There are also elements that cannot legally be included in an employment agreement. For instance, a broker may not include automatic renewal clauses. While Arizona doesn't have one single ARS section banning all automatic renewals for listings, new legislation effective September 2024. Specifically, ARS, Paragraph 4, 44C501, 44502, and 44503, prohibits exclusive residential property engagement agreements, listing contracts, from lasting over 12 months and imposes strict rules, effectively preventing endless auto-renewals by limiting contract length and requiring clear terms, aiming to protect consumers from unfair practices. Additionally, agreements cannot include procuring cause clauses that claim compensation beyond the agreed expiration unless both parties agree to extend in writing. Furthermore, while verbal agreements are common in other industries, they hold no legal standing in real estate transactions involving compensation. The Arizona courts have consistently held that oral promises for commission payments are unenforceable because they violate the statute of frauds. Real-world example. Consider a seller in Chandler who signs a listing agreement with a brokerage, but the agreement fails to include an expiration date. Months later, the property sells under another brokerage, and the first broker attempts to claim a commission. The Arizona Court of Appeals has repeatedly ruled in similar cases that because the agreement lacked a definite duration, it was void, and no commission could be collected. This demonstrates the importance of compliance with ARS. Paragraph 32, 2151-02A3, in every listing or buyer employment agreement. Review summary. Listing and buyer employment agreements are essential tools that legally bind a client to a broker's services. They must include a clear expiration date, identification of the parties and property, signature of all parties, compensation terms, and a grant of authority. Optional terms, such as cancellation clauses and dispute resolution, add structure but are not required. Agreements missing mandatory elements or containing prohibited clauses risk being declared void and unenforceable. Compliance with ARS. Paragraph 32, 2151.02, Paragraph 44, 1017, and R4 28-11-1 ensures brokers can lawfully claim compensation and maintain professionalism in all client relationships. Discussion prompts and answers. Why is a definite expiration date required in all real estate employment agreements? Answer. Because state law prohibits open-ended contracts. This ensures clarity, accountability, and protection against perpetual liability for clients. What are the potential consequences of failing to include compensation terms in an employment agreement? Answer. The broker may lose the legal right to claim a commission since compensation terms are an essential element for enforceability. Why are oral agreements not valid in Arizona for real estate compensation? Answer. Because the statute of frauds requires such agreements to be in writing and signed by the party being charged, ensuring authenticity and preventing fraud.